Court rise. Appeal in the matter of Rt Rev Nicola Baines, Lord Bishop of Leeds and another, and Dixon Coles Gill and another.
Good morning.
My ladies, my lord.
Can I just tell you to start with that you can assume that we have read a lot. We've read obviously your skeletons, the judgments, and we've read all the authorities, and some of us have read more than that also. And on that basis, we're assuming actually that this issue can be dealt with within the morning. We're not in any way trying to squeeze you into any kind of tight pot, but that is our assumption. Put it that way. Thank you.
I'm grateful for that. And just for the introductions, of course, in this appeal, the then Mr. Halpin QC appears on behalf of the claimants, rather the Bishop of Leeds and the Leeds Diocesan Board of Finance, but they are as successors to the Bishop of Wakefield and the Wakefield Diocesan Board of Finance, who were the bodies in place, and the Bishop in place when the causes of action arose. I appear by that fiction of the CPR for the First Defendant Dixon Coles Gill, but that firm no longer exists. And of course, a firm is not a legal entity, so I couldn't appear for it anyway. It is the partners in the firm who are the defendants under Defendant 1, and I only appear for two of the former partners, of course, Julian Gill and Julia Wilding. The firm, Dixon Coles Gill, in which Julian Gill's father and grandfather were partners before him, had a 200-year history until the events which this appeal relates. Linderbox was the senior partner at the time, and is, as you will have learned, was a very respected member of the community, a respected senior partner of the firm, a respected office holder within the Church of England, until Christmas Eve in 2015, when the defalcations were first discovered. And she pleaded guilty and was convicted on her plea to numerous counts of fraud, sentenced to a number of years of imprisonment, which I think now have elapsed, and I suspect she's out of prison by now. And this is part of the fallout, of course, of that behaviour of hers, that despicable behaviour. One, if I just give you one sense of it, she was consoling a fellow member of her church whose son had died prematurely. But at the same time, she was stealing money while administering that deceased person's estate. You also see from the defendants on the title of the action that while normally when solicitors are sued, it's the solicitors' insurers who are the real defendants, but they keep below the radar. In this case, of course, they are defendants as well, named in the action, because they have taken an aggregation point. And they failed on that in front of His Honour Judge Saffman. The aggregation point is pretty crucial. As again you will have seen, there's an insurance cover of £2 million that the firm had, and the insurance company has already paid out £2 million in total. And they maintain that all the frauds by Linderbox should be aggregated together, and therefore their cover's been reached. That, I say, they lost one in front of His Honour Judge Saffman, a trial. They were appealing that, and that is due to be heard before, I believe, a different panel on the 21st and 22nd of July. So that matter still remains unresolved.
Certainly won't be before me, Mr. Chumon, because I won't be here.
Fine. To be honest, my lord, I was surprised to see you here at all. Delighted.
Oh, really?
This matter, the trial below covered a number of different issues, but this appeal only relates to the conveyancing issues, which in a sense are much more straightforward transactions.
And only 4 of the 8.
Indeed, only 4 of the 8, yes. My clients accept that in relation to the other four, they were within the limitation period. Therefore, there is a duty to account. No interim payment was made on that account at the hearing, but that account is to proceed. So,
And so the very narrow question is,
yes, it
in
is.
relation to section 21(1)(a), and whether that applies or does not apply.
Melanie, you're absolutely right, and I sense you're hurrying me along a bit. Can I just say, so you know a bit more, you probably have picked this up again, but I set out the four transactions on my skeleton at page 3 of the skeleton, which is maybe at page 120 of your bundle. The four particular transactions, they total in value, if that's of interest, £661,505 before interest is added. So there's a significant sum involved, but also an important legal point, as the judge accepted when he gave permission to appeal. So
it's odd in a way that the point hasn't arisen before.
isn't it? Yes.
I mean, the predecessor of section 21 arrived on the statute book in 1888. The Partnership Act provisions followed 2 years later.
Yes, well,
Solicitors have been defrauding their clients and, incidentally, their innocent partners for years and years and years,
Yes.
on and off.
well, you're absolutely right. Can I say that what is the extraordinary particular circumstance of this case is the concealed fraud aspect of it, in the sense that, as His Honour Judge Saffman said, it is rather a splendidly direct way, I'd have asked where the cheque was. These are conveyancing transactions. The client, at the end of any conveyancing transaction, says, where's my cheque? Where's my money? The diocese never did do that, it seems. And for that reason, he said that concealed fraud was open to us. And that is not instituted on this appeal. It hasn't been decided, but it's open as to run. So it may be that in most conveyancing transactions, somebody will say, where is the money? Or if they don't, it's because they've been so bedizened by the fraudulent solicitor that they have concealed fraud available to them, and the point may not arise therefore. That's my speculation on that point. You will have seen, therefore, that if I can pick up a paragraph 11 of my skeleton, that this is a claim against my clients as trustees. That is how it's pleaded in the particulars of claim. It's one of the claims against them, the claim as trustee. They also claimed as being liable for her fraud and so on as well, but that's not what the Levin account was in relation to. And of course, if the action was in fraud, then there will be a 6-year time limit anyway, something to consider. So it's the trustee claim is particularly important to the claimants because they hope thereby to avoid
the trusteeship is the trusteeship of the client account.
Yes, it is, yes. And the limitation period applicable to trustees since 1888 is a 6-year period unless you fall within one of the two exceptions. And this, and the exception, the relevant exception here is that the fraud or fraudulent breach of trust, to which, was one to which the trustee was a party or privy. And we say that in very, very simple and straightforward terms, they were not. And the judge accepted that in one sense, that they were personally innocent of any fraud.
Well, it's common ground. But
It is, and that's been very helpful. Yes, absolutely.
so it's really party or privy, isn't it?
Yes, really, well, the meaning of party or privy. And we say that that is determined by Thorne and Hurd.
Yeah.
I'm afraid to say that I did not give the judge the assistance he needed at first instance, because I felt that the statute itself was sufficiently clear. I didn't cite Thorne and Hurd to him, but I cite it to you now. And I have quoted in it one or two of the most relevant bits, but it's worth looking at the case in its entirety. And it's in the authorities bundle, and starting at page 49 is the Court of Appeal. Now, this is not a solicitor's case, in the sense that although a solicitor was involved,
It's not a partnership case.
it's not a partnership case, exactly.
It's
Great
a
point.
client employing a solicitor
Yes,
who turns out to be fraudulent in respect of the funds that they
Yes.
allowed him to receive.
that's right. The clients themselves were the first mortgagees of the property. They sell under their power of sale,
Yeah.
and so therefore they pay off their own mortgage and they become trustees of the balance for the second mortgagee and third mortgagee, as it happened in this case. And it's that trusteeship which brings us within section 21, the trusteeship of the mortgagee. And the important thing to appreciate there about Thorne and Hurd is it had two separate aspects, in the same way that our case has got two separate aspects. It had the section 21 aspect, and it has what I call the section 32 aspect, the concealed fraud aspect. And those are two different matters. One is, I rather inaccurately entitled it for my own purposes, when does time start, which is concealed fraud, and the other is when does time finish, if you like, which is the limitation period for trustees. And if we look at page, perhaps I can just show you page 50, which is part of the argument for the defendants, just to show how the argument was initially put. The last line of page 50 there, it's page 600 of the authority. Chadwick Healy QC says, "We certainly do not come within the first exception, for we had no knowledge whatever of the fraud and therefore could not be a party or privy to it."
Yeah, Mr. Cousins hardly.
I quite admit there was no moral fraud on the part of the defendants.
So,
And then Chadwick Healy goes on, halfway down the page, then upon the question of agency. So it's already showing that in argument they've divided out into two issues. Of course, they've already had a trial. And we pick it up at Lord Justice Lindley's judgment. And it's particularly significant that it's Lord Justice Lindley in this case, because, of course, he has only just recently drafted the Partnership Act. And the Partnership Act is essentially based on his rules about the common law partnership that he's been expounding in his great work for some years. So Lord Justice Lindley, after shortly stating the facts, the final line of that page, the liability of the defendants is clear. They are mortgagees, they are therefore trustees of the balance, they haven't paid it to the right person. That's a breach of that trust. The liability is clear, unless they are protected by Section 8 of the Trustee Act 1888, which makes the statute of limitations applicable to trustees in certain cases. The section is evidently intended to give considerable protection to honest trustees who incurred personal liability by committing some breach of trust. Next paragraph. Upon this enactment and the facts of this case, two questions arise. Viz. One, when did the plaintiff's right of action accrue? That is, when did time start? And that's the concealed fraud point. Two, if it accrued more than 6 years before the commencement of the action, does the case come within one of the exceptions to which the statute of limitations is made inapplicable? That's when does time end, and that's section 21. And if we then follow over the page,
because we don't need to be concerned with the first point about when the cause of action accrued, do we? No.
no, that's absolutely right. In that case, I won't distract you with the marvellous case of Willis and the Earl Howe. A 90-year delay that was, so that must be almost a record. But if we come to page 605 then, in the authority, and page 55 in the bundle, we're still on this question of concealed fraud, and halfway down the page, Lord Justice Lindley says the Trustee Act 1888, Section 8, has in no way altered the principle which determined the issue when a cause of action accrues. See Moore and Knight. And that's what Moore and Knight is authority for. It's not authority for anything in relation to the construction of Section 8 Trustee Act. It's about when the cause of action accrues in relation and concealed fraud. In the case of following lines, in the case of breach of trust, cause of action founded upon it accrues to the Settled Trust upon the commission of the breach of trust in re swain, unless that breach of trust is a fraudulent breach of trust and is concealed by the trustee committing it over some person for whom he is legally responsible. So that's talking about concealed fraud. At the bottom of the page, he says, I come therefore to the conclusion the plaintiff's cause of action gets accrued in 1878, more than 6 years before the commencement of the Act. And the statute of limitations protects the defendants unless the case falls within one of the exceptions. And so now we get to the meat of it for our purpose. I pass therefore to the second of the questions before stated. And he deals with the exceptions. And we've got a pleasantly short, but in my submission, clear and authoritative exposition in the next paragraph. Counsel for the appellant contended the facts of this case brought it within the first exception, frauds to which the trustee has been party or privy. But I am clearly of the opinion that they do not. It is only a misuse of language that a person who in fact knows absolutely nothing of the fraudulent conduct of another, and in who in no way benefits by it or ratifies it, can be said to be party or privy to it. One person may be, and often is, liable in law for frauds which he has not committed. But to say that he is party or privy to them is quite another matter, and is only true when he has personally in some way participated in them. Lord Justice Kay says much to the same.
608.
You have it, my lord. The bottom paragraph. Of course, the defendants are liable, and liable as trustees, unless the statute to which I refer protects them. It has been argued that they were party or privy to Searle's fraud, even if it could be said they were liable for this fraud. It is another thing to say they were party or privy to it. I think that those words in the statute indicate moral complicity, which is not suggested in this case. And there is a passage in relation, I won't take you to it, I may come back to it if I have to reply, but that's what we get from that Court of Appeal decision.
Yeah,
And we say...
Justice Ailes Smith said much the same.
Yes, he did.
At 613.
You have
Not be said to be party or privy to that in which he has taken no part and of which he knows nothing and which has in fact been committed by another for his own benefit. So it's the same.
My lord, it is the same point, and I'm sorry I hadn't spotted it, because I would have piled Oslo Pompilian if I'd seen it, but I was obviously getting so much excitement from the earlier two judgments that I rather got ahead of myself.
And then you've got Lord Herschel.
I have.
To much the same effect in House of Lords.
My lord, I have, and Lord Macnaghten, who has, in his particular trenchant and precise language, says the same thing at Siddons. But Lord Herschel, indeed, and I was going to take you to that, but you've already seen it. That's page 70, page 500, page 72 in the bundle, page 500, Lord Herschel. No, sorry, page 502. That's where he's dealing with the concealed fraud.
At the top of 502.
Yes, exactly.
The first paragraph.
It's there. It's perfectly clear that in order to charge any person with a fraud which has not been personally committed by him, the agent has committed the fraud person could. Oh no, that's concealed fraud point, I'm afraid, my lord. So have I got
the next page. The
yes,
paragraph in the middle.
Right, my lord. The only remaining question, it's halfway down page 503, that's 75 of the bundle. Was the only remaining question is, did the statute apply? It's contended that it did not, because the exception contained section 8. Party or privy. My lords, it seems to me to be impossible, seriously, to say that the respondents were party or privy to the fraud in this case. Fraud was fraud committed by Searle entirely subsequent to the transaction in which they had any interest or any concern, and they neither knew of it, nor assented to it, nor received any benefit from it, or took part of it in any way. On these terms, I'm at a loss to see how it can be said they were party or privy to it. Now, of course, our facts are different from that. There is a material. This was, as it were, a one extra remove. But the simple fact is that the language used by these lawyers all are directed in the same way at what party or privy means. And it's in a sense, particularly important because the concept of party or privy is language which seems to us now somewhat archaic. And in order to understand it, it is extremely helpful to see how it was interpreted in the Victorian era by these judges so shortly after the Act itself was brought onto the statute books.
And you want Lord Macnaghten at the bottom of 504?
I do, and I set him out in my skeleton, I think, but I'd be very happy to take you to that.
That's,
Bottom of 504, he says, "My Lord, I am of the same opinion. By a recent, and I think a very beneficial change of the law, a trustee who has committed a breach of trust is entitled to rely on the statute of limitations as fully as anybody may do who is not a trustee, provided his conduct is free from any taint of fraud, provided he is not in a position to derive any personal benefit from the transaction impeached as a breach of trust." So taint of fraud is his categorisation of party or privy. There. And nothing I was going to look at from Lord Davies, although he describes the statute of 1888 as forming a perfect answer to the claim. In a sense, that's the beginning and end of my submissions on the appeal. My learned friend has put in a skeleton where he raises the arguments he feels he can raise on behalf, and it may be that it's best if I respond to him than otherwise. But I would like just to draw your attention to the authority that he has particularly brought before the court, which is the Compagnia Marittima San Basilio, and the Lord Denny's judgment in 1976. Again, in a very different context. A different statute. It's a question of privity to unseaworthiness, to privity to a ship going out unseaworthy, which is not quite the same thing as being party or privy to a fraud. But there's an interesting examination of the law by Lord Denny, Master of the Rolls. And if I can just draw your attention to one passage there. On page 67 of the report, it's page 98 of the authority file. If we give an introduction, just below C, he says, "I've looked at the history of the word privity in this context and find it to be as follows." But if I could then jump you to the last line of the page, so you don't go through it all. He says, "Historical survey shows, to my mind, when the old common lawyers spoke of a man being privy to something being done, or of an act being done with his privity, they meant that he knew of it beforehand and concurred in it being done." And that's exactly the same point as we see in Thorn and Heard. And he goes on to explain that a bit more. If it was a wrongful act done by his servant, then he was liable for it if it was done by his command or privity, that is, with his express authority or with his knowledge or concurrence. So privity means knowledge or concurrence. Privity did not mean that there was any willful misconduct by him, but there would have to be in this case, because it's fraud, of course. But only that he knew of the act beforehand and concurred in it being done. Moreover, privity did not mean that he himself personally did the act, but only that someone else did it and that he knowingly concurred in it. So that, Lord Denning, his researches have brought us to the same point as we see in Thorn and Heard in my submission.
So your case is that's what privy, party or privy means.
Yes.
And the facts, the uncontested facts, show that your clients are not within either of those words.
Yes.
So one would then be left with the question of what is the effect of the Partnership Act? Does the Partnership Act have some effect of deeming them to be party or privy? I mean, as I understand it, that's rather the basis on which His Honour Judge Saffman decided the case. So
yes,
I'm not quite sure that's...
That was because there was much play made of the ordinary course of business, and that a partner being liable for acts done in the ordinary course of business. And you'll see that even now, my learned friend is relying on that concept in the cases we've been looking at. But that is because that plays for section 32, the concealed fraud point. Because for concealed fraud, you are an agent's acts, or in this case a partner's acts, do allow the concealed fraud point to be taken even though you, the defendant, aren't fraudulent yourself. So the mistake is the crossover, if you like, from that.
Well, I mean, I see that the judge at paragraph 129, recording Mr. Halpin's submission, says the argument was that Mr. Gill and Mrs. Wilding were party or privy because the Partnership Act fixes them with liability notwithstanding their personal innocence.
Yeah.
And then at 135 he goes back to that. Mr. Gill and Mrs. Wilding are not able to claim the protection of the Limitation Act because they're deemed to be party or privy. It's also true that the Partnership Act only fixes them with liability for acts done in the ordinary course of business or in the scope of apparent authority, but it's not arguable that she wasn't acting within the scope of the ordinary business or within her apparent authority. And he says, in the circumstances, it does seem to me there's no limitation period. It's not quite clear where he gets there, but he seems to be accepting Mr. Halpin's proposition that they are deemed by the Partnership Act to be party or privity to their fraudulent partners' acts.
Yeah. But
now, what do you say?
Well, that's dealt with by Lord Justice Lindley himself. But there are many occasions where somebody is liable for the fraud of another.
Lord Justice Lindley knew better than anyone else what the Partnership Act said.
Yes.
But of course, it wasn't a partnership case.
It wasn't, but he would not have been saying something in such broad scope and terms. He would no doubt have had the partnerships in mind. But a partnership may be liable, partner may be liable for the fraud of his co-partner. But that does not mean he's party or privy to that fraud. Well, you're looking at his liability as trustee.
But Thorne and Hurd is not a decision either way on the effect of the Partnership Act in relation to what is now Section 21(1).
No, my Lord. It is a decision, though, that mere liability for fraud, the fact that the law imposes liability on you for fraud, does not mean that you are party or privy to that fraud.
So your contention is that if, as perhaps seems from those paragraphs to be the judge's reasoning, if he is saying, well, the Partnership Act, which of course he's already set out, deems the innocent partners, despite their innocence, to be party or privy to the fraudulent acts of their fraudulent partner, that is simply not to be found in the terms of the 1890 Act.
No, it's not.
And that is what I think he's saying expressly at paragraph 137 of the judgment. And you're saying the reasoning in Thorne and Hurd means that one cannot, as it appears that the judge did at paragraph 137, jump from section 11 of the Partnership Act to the position he took in relation to party or privy. There is no deeming.
No, there isn't. The simple fact is, actually, that my clients, Mr. Gill and Mrs. Wilding, were liable, irrespective of the Partnership Act. In fact, they were liable as trustees.
Well, that's clear from the judgment.
That's clear from the judgment. And in fact, liability of trustees, which they say the outside seem to rely on to avoid there being a 6-year limitation period, but we say no, we fall within the exception as trustees. So then, something of a sleight of hand. They say, well, yes, we're suing you as trustees, but you can't rely on that because you're also partners. And by partnership law deems you to be liable for the misapplication. It doesn't deem you to be party or privy to it. It doesn't say that. Doesn't make that additional jump by any stretch of the imagination.
So that's the point at which, in your contention, the judge went wrong by sliding from liable to party or privy without examining where it might be said that the latter point could be based on the Partnership Act, and finding that it can't.
Exactly. And if one looks at the Partnership Act, just to see its own wording, perhaps that's important, section 11, we've got tab 2, that's pages 11 onwards in the authorities part. And I had a look, in fact, at Lord Linley's book on the Partnership Act yesterday. And he, rather simply and helpfully, describes section 9 as being contract, and section 10 and 11 as being tort. But if we look at 11, because it's that we're really concerned with. Misapplication of money in the following cases, namely, and we look at B, where a firm in the course of business receives money or property of a third person, and the money or property so received is misapplied by one or more of the partners while it's in custody of the firm is liable to make good the loss. So it's liable. It's essentially if there's a claim, cause of action against that.
So the firm is liable, and section 12 means that every partner is liable jointly and severally.
Exactly. But it doesn't say that every party is party or privy to the fraud. It just says they have legal liability for it. And of course, the extraordinary thing is that if it was a purely an action in fraud, of course, there would only be a 6-year time period. That's the
absent trusteeship.
Yes.
Yeah. Well, that's your argument.
You have my argument. Yes, I'll respond to no flame if necessary.
Mr. Hull.
Thank you.
My ladies, my lord, I propose to begin with section 21, 1A. I'll summarise my submissions by reference to the section and will then seek to develop them by reference to the cases. So we have section 21, 1A, starting at page 20 in the bundle of authorities. And the two phrases that are particularly relevant are an action in respect of any fraud or fraudulent breach of trust, and the words which the trustee was a party or privy, to which the trustee was a party or privy. So far as the first phrase is concerned, fraud or fraudulent breach of trust, as far as I'm aware, there's no authority on the meaning of fraud in section 21, 1A, but there is, of course, authority on section 32. Section 32, if the court needs to see it, is at page 25 of the bundle, and we know that the limitation period can be extended for fraud, concealment or mistake. And in that context, it's well established that fraud means a cause of action in which fraud is a necessary ingredient. I hope that's uncontroversial, but if authority is needed, it's to be found in the case of B-Man, B-E-A-M-A-N, and ARTS, 1949, 1 King's Bench 550. I can supply a copy if that would be helpful. But I hope that's an uncontroversial proposition. I'm sorry, my lord.
Beeman and ARTS.
ARTS. And what that
said... Can you just give me the reference?
Yes, 1949.
1949.
1 King's Bench.
Yeah.
550.
Yeah.
And what that case says is that a claim for deceit is a claim for fraud, but a claim for conversion is not, because conversion isn't necessarily fraudulent.
Yeah.
And of course, the same would apply to breach of trust.
Yes.
And in my submission, that must be the reason why the Act says fraud or fraudulent breach of trust.
Yes.
It was necessary to deal with fraudulent breach of trust separately. Now, many of the cases involve fraud rather than fraudulent breach of trust. Our case is concerned with fraudulent breach of trust. But in my submission, we need to look at the cases on fraud because that's where much of the authority is. And I submit those cases are directly relevant because fraud and fraudulent breach of trust are bracketed together in section 21(1)(a), so that whatever privy means in relation to fraud, it also means in relation to fraudulent breach of trust.
Yes.
Lord Justice Millett, as he then was, in Armitage and Nurse, said that fraud meant dishonesty, actual dishonesty, rather than wider equitable fraud. And I don't dispute that. And of course, it is accepted, as my Lady Justice Nicola Davies has said, we accept that the two innocent partners were completely innocent of any fraud. So what I rely on is the fact that Mrs. Box was plainly fraudulent in the dishonest sense, and the question then is whether the innocent partners are party or privy to her fraudulent breach of trust. So turning then to party or privy. Privy is plainly a wider term than party.
Yeah.
It's not disputed that a person is privy if he has actual knowledge or blind eye knowledge. If the person is in a partnership and has knowledge or blind eye knowledge, it's likely that of the fraudulent breach of trust by his fellow trustee, it's likely he'd be a conspirator with him and would be a party to the fraud.
But there is simply no issue in this case of blind eye.
No, absolutely not. But I just make that point to show that privy goes somewhat wider than that. My submission on privy is in two propositions. Firstly, where the fraud is committed by one trustee, the other trustee is not relieved if they are responsible for the fraud, even though personally innocent. And I stress the word responsible.
What?
And secondly, the innocent trustee is responsible if the fraudster was their partner and the fraud was committed in the course of the partnership business. And that's the proposition which I need to develop.
And are you going to elaborate on what you mean by responsible?
I am, my lord, yes. I am. If I may, I'll do it by reference to the authorities.
Yeah, sure.
But just before I go to them, the Partnership Act, section, my learned friend quoted Lord Linley in his textbook, saying that section, I think he said section 10 was concerned with contract and section 11 with tort. So 9 with contract and 10 with tort. My lord, that I'm afraid is, despite the eminence of
Doesn't stand with Lord Millett.
it doesn't, indeed. And your lordship has seen it in Dubai and Salam at paragraph 110. There is a rather wider definition. I should say, does the court have Dubai and Salam in its appeal cases version?
Yes, I think we do.
But originally it was provided in the All England version, and curiously there was actually a mistake.
No, we've got the appeal case.
No, we've got them.
I'm grateful. So Lord Millett says that section 11 is concerned with original liability, whereas section 10 is a liability for which the partnership is vicariously liable. But section 11 is an original liability, and each of the partners is liable for the original liability of the firm. And in my submission, that is what makes the difference. May I turn then to the authorities? I should say one other thing. One perennial difficulty which the law has to deal with is which of two innocent persons should suffer for the fraud of a third party. The approach of the common law, for example, the law of mistaken contract, is not necessarily going to be the same as the approach in equity. The reason for the difference is that in equity, the defendant trustee owes fiduciary obligations to the claimant beneficiary. The trustee is responsible for having put his fraudulent partner into a position where they can carry on fraud in the ordinary course of the partnership business.
Well, that's of course why he is vicariously liable, as the Partnership Act shows.
Yes. My Lord, yes.
It's another step to say that he's party or privy.
My Lord, I accept that, but as a
You're
trustee,
going to take us to that step.
As a trustee, he has a responsibility to
Oh, yeah.
his beneficiary, and added to that, he's also a partner.
Yeah.
My Lord, if I can start with Blair and Bromley, which is at tab 4 in the bundle, starting at page 28. Now, the state of the law in 1847, or rather the state of equity in 1847, was firstly there was no limitation period for claims against trustees. My Lord, that is a point that was noted by Lord Macnaghten in his...
Well, it was the 1888 Act that introduced it for the first time.
Indeed. So before 1888, there was no limitation period for trustees.
Yeah.
And secondly, equity did not allow a defendant to rely on any statutory limitation period where the cause of action had been fraudulently concealed. So that's the background against which Blair and Bromley was decided. Now, Lord Cottenham's judgment, which begins on page 31 of the bundle, page 982 of the report. In his second and third paragraphs, he makes it clear that a fiduciary obligation, that equity holds a fiduciary liable even if he has no knowledge or means of knowledge of the wrongdoing. I accept that where it says 360 in the middle of the page, he says the Act consists in representing that the £4,500 had been invested on that security. So he is focusing there on misrepresentation or concealment. But if we go to the top of his judgment, the first sentence, he says the payment of the £4,500 into the funds of Bromley and his partner for the purpose of investment is proved and their liability admitted. So there is plainly a breach of trust as well as a concealment of it. And in my submission, although it's not the main focus of the case, it is a case on breach of trust as well as on concealment, and there was no limitation period in those days for breach of trust. Now, later cases, as we'll see, have treated it as laying down the test for who is privy. And in my submission, sorry, for who is privy, the later cases say this.
What did that have to do with the decision around Bromley?
My Lord,
Privity had nothing to do with it.
no, privity wasn't a term that was then in use because it was introduced by the 1888 Act. But the later cases do refer back to Blair and Bromley, and in my submission, they are treating it as an authority on the meaning of privy. And although the cases may be in the context of fraud, I submit the same must apply to fraudulent breach of trust because privy is used for both. The next case is Hughes and Twisden. Sorry.
So what is it in Blair and Bromley that later cases found of any assistance on privity?
My Lord, the paragraph beginning with the second paragraph, whether the defendant knew of the transaction or not, the means of knowing, but neither is necessary. but the duty of laying up the money was in the ordinary course of business.
It's an absolute duty.
Yes. And then in the next paragraph, those who have a duty to perform represent to those who are interested in the performance that has been performed, make themselves responsible for all the consequences of non-performance. This is deeply rooted in our equitable jurisdiction. So in my
So
submission,
this is all about liability and not all about privity.
my lord, it's about liability for breach of trust and also about concealment.
But not about privity. It has nothing to say about privity, which is not surprising because it wasn't a relevant concept.
I see the force of what your lordship says. The next case is Hughes and Twisden, and I summarise the facts in my skeleton argument. There were three separate claims, so we need to distinguish between them. The judgment begins in the law report at page 483, Mr. Justice North, and he begins by dealing with a claim for misrepresentation, which we're not concerned with, and which failed on its facts. So we can pass over that page. Then on page 484, in the second column, he looks at a claim for negligence, which we're not concerned with. And then finally, at the bottom of, at the bottom of page 484, he refers to Blair and Bromley and says over the page at 485, transaction of 1869 results in negligence and the statute of limitation is a bar. So there's the reference to Blair and Bromley, but that's not what we're concerned with.
Yeah.
It's the next paragraph that's relevant. Then we come to the transaction of 1875. There was no fraud on the part of any other member of the firm than Parker, unless the other parties are liable for Parker's fraud. So I rely on that sentence. The fraud consists in depositing the deeds as the first charge, making a legal mortgage, concealing the prior equitable encumbrance. If the £1,500 had been received by the firm, it might have been a different matter, but it's not suggested that the firm knew anything about it. What is the liability of the firm in respect of one partner's fraud? Fraud was not done in the ordinary course of the partnership business. Well, what Mr. Justice North appears to be saying there is that if the money had been received by the firm and had been received in the ordinary course of the partnership business, there would have been a different result. And of course, in those days, ordinary course of partnership business had a much narrower meaning than was later given by Lloyd and Grace Smith, and is clear from the Dubai aluminium case.
So you're entitled to say that on these facts, somewhat later in the development of the law, it would have been held, it may very well have been held,
Yes.
to have been done in the ordinary course of the business of the firm.
Yes.
And if that had followed, then the other partners would have been liable
Yes.
for the wrongs, the frauds, indeed fraudulent breaches of trust
Yes.
of their partner,
Yes.
but not because they were privy or party, because again, that wasn't a relevant concept.
My lord, I accept this was before the Act, but these cases have continued to be cited.
And you drew attention to there was no fraud on the part of any other member of the firm than Parker, unless
Yes.
the other members are liable for Parker's
Yes.
fraud. What does that mean?
My
Unless
lord,
they're liable.
I submit what that means is that if the other partners, though personally innocent, if the fraud had been committed in the course of the partnership business,
Yes.
they would be liable for it, even though they're
Well, they would
personally
be
innocent.
liable, wouldn't they?
Yes.
It doesn't mean that they would have been fraudulent themselves. They just would have been liable for the fraud on the principles that were later established in the Partnership Act and had been established by the development of the law.
Of course, although the Partnership Act postdated this case, it
Yes.
reflected the
Yes.
state of the law. But my lord, there is a difference between the original liability and the vicarious liability.
Yeah.
And the liability for breach of trust is an original liability, and it's a fraudulent breach of trust. And in my submission, that is sufficient.
But
But it doesn't help on privy.
no, but I still would like you to show me where we get the extra step from Hughes and Twisdon, because it seems to me that what is being said
Yes.
on page 37 of the bundle and 485 of the report is, in effect, what becomes categorised when the 1890 Act is enacted.
Yes.
But that's all, and it doesn't take me personally the next step in order to determine whether, nevertheless, the partner who becomes liable,
Yes.
if the act is in the ordinary course of business of the firm,
Yes.
also is privy, which is, I think, exactly the same thing as my Lord Justice.
And it didn't matter
Lloyd is saying.
because that word hadn't come onto the statute book because there wasn't any limitation period for breach of trust.
My lady, I accept that what my lord has said must be right, that the word privy isn't directly being used.
Yeah.
But what seems to be contemplated there, and it's how this case is treated in later cases that will be relevant.
So we'll find it later when we're looking at how this case has been interpreted.
And Blair and Bromley, yes.
Okay.
Yes.
So Moore and Knight?
So Moore and Knight is the next one, and this, of course, does post-date the Trustee Act of 1888.
Yeah.
And Mr. Justice Sterling, his judgment begins in the bundle, page 43. He sets out a long extract from Blair and Bromley, and then at page 46, in the middle of the page, referring back to Blair and Bromley, he says, "It appears, therefore, that the money came into the hands of the firm of Messrs. Bromley without fraud, and that one of the firm afterwards committed a fraud in respect of it, but made misrepresentations, some of which were attributable to the firm, which prevented the fraud from being discovered until the period fixed by the statute of limitations had expired. Held that the innocent partner was deprived of the benefit of the statute by those representations which bound him as a partner. The decision rests on principles of the law relating to representation and to partnership, not on those which relate to trusts. In my opinion, those principles are unaffected by the provisions of the Trustee Act 1888. My Lord, what's being said there is that the Trustee Act 1888 introduced the term privy, and that is the term which appears in section 21, and that term makes no difference to the liability of an innocent partner for the fraudulent breach of trust of the firm, albeit that it was actually done by his partner and he was innocent of it.
It's treating Blair and Bromley as a case in misrepresentation, not in breach of trust. Is that fair?
But my Lord, we certainly saw from the judgment that it is put primarily in terms of misrepresentation, but both steps are there. In the third line of the paragraph I read, the firm committed a fraud but made misrepresentation. So there's the two elements to the case.
Well, it's true, I suppose, that Blair and Bromley was a case that involved misrepresentations to conceal the fraud.
Yes.
So what, do we get more from Moore and Knight?
My Lord, only that it
The money of the plaintiff came without fraud into the hands of the firm for investment.
Yes.
No investment was made. The money was, by some act, of which I am willing to believe William Gregory was innocent, misappropriated, and applied for the purposes of the firm. Now that's interesting. Not applied for the purposes of the fraudulent partner. If it was applied for the purposes of the firm, then one can see that the second exception in 21 might apply.
Yes. And that is indeed discussed, although no conclusion is reached. My Lord, it's page 44 of the bundle, page 553 of the report. In the second paragraph.
Yeah.
Last exception.
Yes.
Unnecessary to express a final opinion. The second argument on behalf of the plaintiff ought to succeed. What was the second argument?
Is it at the top of that page, 553 or page 44? To the argument based on the statute, it was answered first that the case fell within the specified exceptions, and secondly,
yes,
that even if the statute applied, a trustee was under it entitled to the benefit of the statute of limitations only in like manner, etc.
Yes.
Yes.
My Lord, I then move on to Thorne and Hurd.
Yeah.
Now, Lord Justice Lindley's judgment begins sorry, I should say, first of all, looking at the argument, Mr. Cousins-Hardy QC, at page 50 of the bundle,
Yeah.
towards the end of his argument, says neither can the defendants claim the protection of Section 8 of the Trustee Act 1888, for they fall within the exceptions shall not apply in respect of any fraud or fraudulent breach of trust to which the trustee was party or privy, or where trust property is retained. So he was arguing both points.
Well, he was, but
Yes.
But actually, well, yes, okay.
Yeah, my Lord, the reason I refer to that is that over the page, the court noted that Mr. Cousins-Hardy says, I quite admit there was no moral fraud on the part of the
Yes.
defendant, but that didn't stop him from arguing that they were nevertheless party or privy.
Yes.
That's the point. And Lord Justice Lindley...
He didn't get very far with that.
No, he didn't, but the facts were completely different.
Yes.
In my submission. Because if we look at the bottom of page 53, the fraud...
Yes, and I can see that at the conclusion of his argument as reported on 52, to render the defence liable, it's not necessary that they should have been party or privy to the fraud. It's sufficient that the fraud was committed by their agent.
Yeah.
So he had two,
Yes.
at least two,
Yes.
arrows to his bow.
What we see at the bottom of page 53 is Lord Justice Lindley says the fraud thus perpetrated and concealed by Searle cannot, in my opinion, be treated as perpetrated or concealed by the defendant, knew nothing of it. In perpetrating and concealing the fraud, Searle was not acting or even purporting to act for the defendant. He was acting fraudulently in his own interests, pretending to the defendants that he had authority from Thorne to receive the amount due to him, undertaking to remit to him, pretending that the security was still subsisting and paying interest. And then he says over the page, these frauds of Searle cannot be regarded as the frauds of the defendant. That is, as frauds committed by their agent for them or for their benefit, and for which they are legally responsible, although completely innocent of all fraud themselves. Then he looks at Blair and Bromley, and in the second sentence of that paragraph, he says the fraudulent transaction was itself the cause of action, and the innocent partner was liable for that fraud, and it was concealed by the fraudulent partner. And then in Moore and Knight, he says, was a similar case. The fraud and its concealment were, though committed by one partner, imputable to the firm. Now, going on to page 56 of his judgment, passage that my learned friend relies on is the second full paragraph beginning counsel for the appellant,
Yes.
page 56. And towards the end of that paragraph, he says one person may be and often is liable for frauds which he has not committed, but to say he is party or privy to them is quite another matter, and is only true where he has personally in some way participated in them. Defendants were, in my judgment, in no sense whatever either fraudulent themselves or parties or privies to the fraud. Now, I can see why my learned friend relies on that, but in my submission, that is a statement made in the context of the facts of that case, where he was not acting within the partnership.
Well, it wasn't a question. It wasn't a case of partnership.
No, no. My Lord,
I mean, what the observations of the judges in the Court of Appeal and in the House of Lords give us
yes,
is at least a flavour, not a definition, but an indication
yes,
of what was then understood by the words party and privy.
yes. May I go to Lord Justice A.L. Smith? My Lord has already referred to the passage in the middle of page 63, but I'd like to go on to page 65, where he refers to the case of Charnwood Forest, which set out the law as then understood in relation to course of partnership business. And then says, if the plaintiffs were attempting to sue the defendants, the damages occasioned to him by reason of the fraudulent acts of Searle, he couldn't, in my judgment, succeed, because the principal is not responsible for his agent's fraud perpetrated in his own interest. Then why are the defendants not to be allowed to rely on what the statute permits them to set up and rely on? That's section 8. If they have not been guilty of some fraud themselves, or of some fraud for which they are responsible. And that's where I get the word responsible from.
As you say, as a result of the partnership act, the innocent partners are responsible.
Yes, yes. Precisely.
But that, yes, I mean, that's a further step from what the Lord Justice was saying here, since he wasn't considering a partnership.
My Lord, I accept it's not direct authority, but it's an indication of what his thinking was.
Yeah. Well, it's not that far from what he'd said at 613. Cannot be said to be party or privy to that in which he has taken no part, which he knows nothing has been committed by another for his own benefit, or for that matter from Lord Justice Kay and Lord Justice Lindley.
My Lord, if my
Some
submission...
fraud for which they are responsible
Yes,
poses the question, what do you mean by responsible?
yes.
And it was clear in Thorn and Hurd that the defendants were not responsible for the fraud of Searle, so it wasn't necessary to consider what might have made them responsible, I suppose. Yeah.
Well, I accept it's not direct authority, but in my submission it is a helpful indication that where there is a responsibility through the partnership, a different result might follow. May I turn then to what the House of Lords said on the next tab. So Lord Herschel gave the first speech at at page 74 of the bundle. First full paragraph, appears to me perfectly clear. In order to charge any person with a fraud which has not been personally committed by him, the agent who has committed the fraud must have committed it while acting within the scope of his authority, while doing something and purporting to do something on behalf of the principal. The person is doing something within the scope of his authority and purporting to do it for his principal, although in doing it he commits a wrong which his principal neither sanctioned nor intended, the principal may be liable. But if the person, although he has been employed as an agent, is not in the transaction which is the wrongful act, acting or purporting to act for the principal, it seems impossible to treat the fraud as that of the principal. So there he's saying that the fraud is to be treated as the fraud of the principal. in a case where there is an agency or we would say partnership. Going over to page 75, in the middle of the page, Lord Herschel says, the only remaining question is, did the statute, that's section 8, apply? It's contended it didn't because of the exception contained in the first subsection. It sets out the words. Lord, it seems to me to be impossible seriously to say that the respondents were party or privy to the fraud in this case. The fraud was a fraud committed by Searle entirely subsequent to the transaction in which they had any interest or concern, and they neither knew of it, nor assented to it, nor received any benefit from it, nor took part in it in any sort of way. Under these circumstances, I'm at a loss to see how it can be said they were party or privy to it. Well, what I get, my lady, what I get from that passage is that here Lord Herschel is looking specifically at section 8, which is now section 21.
Yes.
He's not looking at deliberate concealment, which would now be section 32. And he's saying in the course of, in relation to the term privy in section 8, now section 21, that a fraud which is committed by an agent, even if the principal is personally innocent, or by a partner, even where the other partners are personally innocent, is to be attributed.
Where does he say that?
He says he's considering the argument that they are exempted. He's considering the argument that section 8 doesn't relieve the trustee because he was a party or privy.
Yes.
And he says it's impossible to say they were party or privy.
Yes.
And then he explains why. Because, but the implication is that had it been a fraud committed in the course of the partnership business, then they would have been privy. Otherwise, he would simply have said there is no circumstance in which somebody who has no knowledge can be liable. But he doesn't say that.
So, what you draw from this paragraph is that Lord Herschel would have come to a different conclusion if the fraud had been committed by Searle within the scope of his agency.
My lord, yes, yes.
And you get that from the paragraph in the middle of the page on 503 and the top of 502.
Yes.
Where he says, it appears to me perfectly clear that in order to charge any person with a fraud which has not been personally committed by him, the agent who has committed the fraud must have committed it while acting within the scope of his authority.
Well, yes. I mean, what the Lord Chancellor says, of course, is that the defendant wasn't responsible, wasn't party or privy in the circumstances of the given case.
Yes.
It's taking the proposition quite a bit further to say, but if he had been, then the result would have been different.
My lord, of course I have to accept this as obiter, otherwise we wouldn't be arguing it in the Court of Appeal. Yeah. It would have been decided. But in my submission, it is the clear implication of what he's saying, because he's basing his decision on the fact that they were not, that it was not in the course of the partnership business, although they were not an agent, rather than on the fact that he had no knowledge.
Within the scope of the agency.
Yes, yes.
And they neither knew of it, nor assented to it, nor received any benefit from it, nor took part in it in any sort of way. I mean, if it had been within the scope of the agency, in principle,
yes,
as a general rule, the principal would have been liable for the agent's wrongs.
Yes.
Subject to the question, perhaps, of limitation.
My lord, yes, but the point about agency is being made in the context of Section 8 as an answer to whether he was party or privy. And the answer that he was not party or privy is because the fraudster wasn't his agent.
Well, That's taking part of the sentence starting the fraud was a fraud committed by Searle, and not the whole of it. Anyway,
My Lord,
have your submission.
may I take your Lordship to Lord Davies? We haven't looked
Lord
at
Davies.
his speech.
Yes.
Page 78 of the bundle, about halfway down the page. On the other point, that the statute did not begin to run until within 6 years of the beginning of this action. Only desire to say this. My opinion, if a fraud or non-discovery of a fraud, so it's both fraud and concealment, is to be relied on to take a case out of the statute of limitations, it must be the fraud of, or in some way imputable to the person who invokes the aid of the statute of limitations. Now, the fraud which is imputed to Searle, and apparently justly, is that he put Thorn off his guard by continuing to pay his interest to him as if the security was still subsisting. Lords, it cannot be pretended for a moment that he was acting as agent for the respondents in doing that. He did not make the repayments of interest in his character of agent for the respondents, he made them as agent for the mortgagor, and I can see no foundation whatever upon which Searle's fraud can be attributed to the respondent or can be said to have been committed by him while he was acting in the character of the respondent's agent.
Yeah.
So, my Lord, that passage, again, in my submission, supports the way in which I read Lord Herschel's speech. He uses the word imputable, which is similar to Lord Justice A.L. Smith's responsible. He's looking specifically at Section 8, and he's deciding the case on the basis of agency and not on the basis, or lack of agency, and not on the basis of lack of knowledge.
Yes, but I think, isn't it fair to observe that on page 505, Lord Davies starts, the third paragraph says, two questions argued. First, whether the case is not within one of the exceptions in Section 8.
Yes.
Secondly, did time begin to run only into a period less than 6 years before the commencement of the action? I do not desire to say anything more than has been already said by your lordships, more than is contained in the judgments below upon the first point. And then he goes on to the second point, and that's what he's dealing with on page 506.
But, my Lord, the state of the law at the time, as I understand it, was that Section 8 of the Trustee Act, which is now Section 21, was in force in relation to claims for breach of trust,
Sure.
whereas the law in relation to concealment was still equitable.
Uh-huh.
I think I'm right in saying that. Looking at my learned friend who smiles at me.
Yes, you are. Not the real point.
But there's certainly no reference in the law reports to any equivalent to what is now Section 32.
No.
And so when Lord Davies goes on to deal with Section 8, he can only be dealing with it in the context of breach of trust rather than concealment.
Yes. Well, where is he dealing with Section 8?
Lord Davies deals with it at page 78.
Oh, where does
He
he
refers to
mention
the
it?
statute.
Where does he mention it?
My Lord, first of all, he mentions it in the second paragraph on page 77, his second paragraph. I am of opinion that the statute of 1888 forms a perfect answer to the claim.
Yes.
And then over the page,
Sorry. Where is? Oh yes, the end of the second paragraph.
that's it, yes. And then over the page, in the paragraph halfway down the page,
Yes.
the statute did not begin to run until within 6
Well,
years.
the statute doesn't begin to run. Yes, that's the separate point. Isn't it? Deferring the beginning of a limitation period. That's different from Section 8. That's concealment.
Well, I see that Lord Davies' speech can be read that way.
Yeah.
In my submission, Lord Herschel's speech remains clear on the point.
Very well.
But, my lord, there's certainly no authority to the contrary. My learned friend is not able to point to any authority which supports his case. For what it's worth, I've brought and blown up the relevant extract from the Oxford English Dictionary, which is not easy to read, but I've made it into a A3 size. Did I?
On the meaning of the word privy?
Yes. I should say that in my skeleton argument, I wrongly referred to definition 6 on the first column of page 524, law. That's actually privity rather than privy. But privy begins up near the bottom of the first column on page 524. And if Ladyship and Your Lordship will go over the page, the second meaning is law, under the heading law, first column of the second page, about a quarter of the way down. One who is a partaker or has any part or interest in any action, matter or thing, including the parties entering into a contract, and also one that is bound or has an interest under a contract or conveyance to which he is opposed, to which he is not a party, opposed to stranger. And in my submission, the word stranger is helpful in this context, and it suggests that a privy is someone who's not a stranger, and that would certainly be relevant to a trustee or an agent-principal relationship.
Yes.
My learned friend referred to the case that I quoted in my skeleton argument of the Compagnia Maritima San Basilio. When I put that skeleton together, it seemed to me to be relevant. Having come back to it, it's a case on a different statute,
yeah,
and probably less relevant. But what I was seeking to gain from it, which I'll just take very briefly because I appreciate it's some way removed, and that is that Lord Denning refers to he refers to an individual ship owner, and he refers to a company which is a ship owner. And in the case of the company, he says, sorry, just find it. Page 68 of the report, page 99 of the bundle, next to the second hole punch. The knowledge must also be the knowledge of the ship owner personally, or of his alter ego, or in the case of a company, of its head men, or whoever may be considered their alter ego. So although he's saying knowledge is necessary, he's extending it in terms of attribution in the case of a company, and I submit that the same could be done in the case of a partnership. But I appreciate that is some way removed from our case.
In the case of a company, you've got to extend it because you've got to find a human mind into which to find the knowledge.
My lord, my ladies, the overall conclusion to which I invite the court to come is that a trustee who is personally honest is nevertheless privy to a fraud or a fraudulent breach of trust if he's in a relationship of partnership with the dishonest trustee, and that result is a just one for the reason given in the end of my skeleton argument, and that is that beneficiaries rely on partners. The partnership does act in the ordinary course of its business. They're entrusted with money, and one partner leaves it to another to do acts, obviously expecting them to be honest, but thereby creates a relationship in which fraud is able to flourish. And as between the innocent partner and the innocent beneficiary, it's right that the innocent partner should carry the responsibility, because he is the one that put that partnership structure in place and conferred the authority on the fraudster to commit his fraud. And I turn my back for a moment.
That, in a sense, is your second proposition, where my note is that privity, well, the defendant, the person sued for the fraud,
Yes.
is privy to the fraudulent breach of trust if the fraudster was a partner
Yes.
of the defendant and the fraud was committed in the ordinary course of the partnership business.
Yes, that's right.
So if that's right, you don't need your first proposition, which is that the other partner is not, the other party is not relieved if he or she was responsible for the fraud, without really defining very much by what you mean by responsible.
My Lord, I submit that the responsibility derives from the partnership structure.
So it doesn't add anything to
No.
the proposition.
It's the same
The
point.
liability comes from the partnership and from the wrong being committed in the ordinary course of the partnership business.
Precisely.
That is how I had understood your propositions. That
Yes.
actually responsibility arises from the partnership, and so it's the same point expressed in different ways.
Yes.
I mean, obviously there could be cases not concerning partnership where responsibility might be a useful analogy, but we don't need to consider that in the present case because it begins and ends with partnership.
It does. And the reason I chose the word responsible is because Lord Justice A.L. Smith had used it in Thorne and Hurd.
And in the same way, you rely on what Lord Davies said about it being imputable.
My Lord, yes. My Lady, yes. And also what Lord Herschel said.
Yes.
Mm-hmm.
May I turn my back for a moment? My Lady, unless I can insist further, those are my submissions.
No, thank you. Thank you very much, Mr. Halpin. Mr. Dumont?
I don't know how much help you're going to get from me now because I made my submissions in opening, but can I just make sure that we understand cases such as Moore and Knight and Thorne and Hurd accurately? Moore and Knight was a case where again, two issues arise. One is the liability of the firm. I'm sorry. The two potential issues in Moore and Knight were Section 8 of the 88 Act, which is now Section 21, and Section 32, which is what is now Section 32, but then was common law, equitable law of concealed fraud. And Mr. Sterling was absolutely clear that while he considered the possibility of Section 8, and that's on page 553 of his judgment and paragraph 44, he was putting it not into the party or privy category, but he was putting it into the other category of trust property or proceeds previously received by the trustee converted to his use. So it's certainly not any help at all on party or privy. But he didn't even find it necessary to form any conclusion upon that Section 8 point. although it would be a different one from today, because the concealed fraud point succeeded. The concealed fraud point then and now applies to somebody applies to a person who is either fraudulent or whose agent was fraudulent. Section 32 is express on that, and the law was the same, common law was the same. So all questions of agency, all questions in the sense of ordinary course of business and so on, go only to the question of the concealed fraud point. They don't go to the question of whether somebody is party or privy. And in Moore and Knight, as I understand it. No, well, let's leave it there. What they're saying is that the old law about concealed fraud delaying the start of the limitation period still applies, even though a limitation period is available now. The earlier cases, Blair and Bromley, was in fact not a breach of trust case, it was a case in either negligence or in tort, essentially. So the statute would have applied otherwise, but therefore the claim system concealment of fraud and extension was important. Thorne and Hurd again.
But before, I'm sorry, if I can take you back to Moore and Knight, page 555, in the middle there, I just would be grateful if you tell me what you say is being considered there and what the last sentence means. The decision rests on principles of the law relating to representation and to partnership, not on those which relate to trusts, and in my opinion, those principles are unaffected by the provisions of the Trustee Act 1888.
Yes, indeed. It appears, therefore, take the paragraph that's like, the money came to the hands of the firm Mrs. Bromley without fraud. One of the firm masters committed a fraud in respect of it. It came into the hands of the firm to be laid out upon, the money came into the hands of the firm to be laid out upon mortgage. And the original cause of action against them, if I can find it, was a cause of action in breach of contract, I think, for an implied contract to lay the money out on on the investment intended. It never was so invested. And it was the defendant who tried to rely upon the trusteeship and therefore the limitation period. Looking at page 44, it's 46, wasn't it? It appears, therefore, the money came in the hands of the firm Bromley without fraud, that one of the firm masters committed a fraud in respect of it, but made misrepresentations, some of which were attributable to the firm, which prevented the fraud from being discovered until the period fixed.
Sorry, where's that?
Statute of limitations. I'm sorry, we're on page 555, 46 in the bundle.
Yes.
Halfway down.
Yes.
Came in without fraud. A fraud occurred by the partner himself, and that's a tortious wrong. He then makes misrepresentations which prevented the fraud from being discovered until the period fixed for the statute of limitations had expired. A 6-year period for the statute of limitations. But the misrepresentation postpones that, the starting of the period. Held that the innocent partner was deprived of the benefit of the statute by those representations which bound him as partner.
So that's
talking about Bromley.
talking about Blair and Bromley.
Talking about Blair and Bromley.
Yeah.
Exactly. Blair and Bromley, there was no trustee limitation period available. It was a breach of the implied contract under which the money was received by the solicitor. That was the cause of action. That had a 6-year time period at law under the statute of limitations, but that was delayed because of the fraudulent misrepresentation of a partner acting in the course of his partnership. That was purely, therefore, about concealed fraud, delaying the start of the limitation period. That's a section 32 point. The decision rests on the principles of the law relating to representation of the partnership, not on those of the trusts. In my opinion, those principles are unaffected by the provisions of the Trustee Act 1888. The trustee exemption, the trustee limitation period, brought in 1888, is still governed by the concealed fraud provisions.
So it's all about what is now section 32,
Yes.
and it's got nothing to do with what we're talking about.
Yeah.
Okay.
So
You've got it.
The last part of that sentence is basically to say, okay, we've got this 1888 Act, but it has nothing to do with the law relating to representation or partnership.
Yes. The trustees have now got the benefit of a limitation period, but that is to the same extent as anybody else can rely on limitations. And that carries with it the suspension of the limitation period during a period of concealed fraud. Yes. You have that point. And that is also what is being discussed again in Thorne and Hurd, particularly by Lord Herschel at 502. If you start at 501, Lord Herschel's judgment 501, bottom of the page. Now, my lords.
I'm sorry, I'm slightly lost.
Yes. It's page 73.
No, I
in the
have it
bundle
now,
page.
I'm sorry.
Divider 8,
Yes.
and it's page 501 of that.
I've got it, thank you. I'm
I'm
sorry.
sorry, it comes twice. Page 501 there. Now, my lords, the question arises whether the statute of limitations can be pleaded. First, it says that the right did not arise until 1892 when the fraud was discovered. So that's the concealed fraud point. That's section 32. But there was here concealed fraud, that although there was no fraud on the part of the respondents, it is not alleged, nor any concealment on their part, yet there was a fraud on the part of the person acting as their agent. See, again, that's the agency allows in concealed fraud, namely concealment by Searle, who was the agent respondent, and that consequently it was not until the discovery that any cause of action arose. So he's dealing entirely with the concealed fraud point at that point. Entirely unable to give any counsel to such an argument, it appears to be perfectly clear that in order to charge any person with fraud which has not been personally committed by him, the agent who has committed the fraud must have committed it while acting within the scope of his authority or doing something reporting something above the principle. That's looking at it in terms of the agency which gives rise to the argument for concealed fraud. That's what we're looking at there. It's an entirely different point to the point on section 2.
And then at 503 he comes on to the section 8 point.
He does. He does. And there's no discussion of ordinary course of business or any of that sort of that scope here. The only remaining question is, did the statute apply? It was not suspended, we know that, but did it apply? In fact, it did not, because there's exception contained, except where the claim is found on any fraud or fraudulent trust, to which the trustee was party or privy. And also, it seems to be impossible seriously to say the respondents were party or privy to the fraud in this case. And he goes on and sets out why, what it is that you need to show to be party or privy. So, committed by Searle entirely subsequent to the transaction in which they had any interest or any concern. Well, that's the setting of the facts. But then he says they neither knew of it, nor sent it to it, nor received any benefit under it, nor took part in it in any sort of way. So, showing you exactly what the scope of party or privy is, and it's a strong term. liability is one thing. Party privy is something very, very different. But then a friend, in appeal to you at the end of his submissions, describes this as the sort of case where two innocent parties and a fraudster. The innocent party being the client and the partners. Who is to bear the liability? Who is to bear the loss, if you like? Who bear the loss? And of course, we were fixed with the liability for 6 years. We were liable for it.
Yes.
That's what the law said. Even though we were innocent, we were liable. But it has given us, since 1888, the benefit of that limitation period. And we haven't yet had the fight about Section 32.
No.
And we may yet lose it. And if that's so, then we will still be liable. My clients will be ruined. But liability is not party or privy.
Thank you very much. We have no further questions. Thank you for dealing with this interesting issue so succinctly. It won't surprise you that we will reserve our judgments. They will be dealt with in the usual way, and you're very familiar with that way. Drafts will be circulated. We'd be grateful if you would refrain from the temptation to comment and only deal with typographical errors. And also, as you'll also know very well, all consequential matters should be agreed if possible, and if not, short written submissions should be submitted, and we will deal with those issues on paper. There is a mixed practice at present whether things are handed down under COVID regulations or not, and I can't tell you which will be applicable in this case, but you will be informed. I think those are all the relevant matters. Thank you.